Hello, everybody. This is Charles Lincoln again from New Orleans. This happens to be the 6th anniversary of my mother's death, and I'm finding it a little bit difficult. Hello, everybody. This is Charles Lincoln again from New Orleans. This happens to be the 6th anniversary of my mother's death, and I'm finding it a little bit difficult. Hello, everybody. All right, I think I got rid of the unpleasant. I think I got rid of the unpleasant feedback there, and I think I know what's causing it now. But anyhow, this is the 6th anniversary of my mother's death, and I'm finding it difficult to sleep. And so I thought I would say a little prayer on the 27th of October. My mother in heaven, look down on me and forgive me my sins, for they are many. But I also wanted to talk about some very strange things that are going on in the world today, including one of them, which I want to focus our attention on today, the complete useless perversion of the legal system. My mother was never very happy about my going into law, and I don't entirely blame her. Anthropology and history was a much more civilized, gentlemanly pursuit, but oh well. The reasons I went into law from anthropology and history are very complicated and of no interest to anyone now living or dead. But I have to say that one of the things my mother taught me was a love of and fascination for Dante's Inferno. And as some of you may know, the words to the Canto 4 of the Inferno are the words written over the gates to hell. And one of the phrases there is, Justitia mosse il mio alto fattore. Justice moved my maker on high. Justice. Per me si va nella città dolente. Per me si va tra la gente perduta. Dinanzi a me non fuor che cose create, e io eterna adoro. Fecemi la divina potestate, la somma sapienza, il primo amore. Divine power made me, supreme justice, supreme wisdom, and eternal justice, eternal love. Fecemi la divina potestate, la somma sapienza, e il primo amore. Divine power made me, supreme justice, and eternal love. The legal system that exists in the United States today has nothing to do with any of that. And the sooner people grow up and realize that nothing in the legal system really matters except brute force and money, the sooner we will be able to get along with things. And I just want to throw something at you. Specifically, I want to throw this immense, absolutely immense docket sheet at you. See if I can do that here. Screen, yes, I can. I want to throw at you the docket report in Signs v. Kessler. There is no somma sapienza, primo amore, or anything like that. There's no wisdom or primal love or divine justice in here. As a matter of fact, I think it's fair to say that this case is a caricature of wisdom and justice and eternal love. And let's just start by looking at it. The docket sheet as of the end of business on Tuesday, I don't know what's been filed tonight, but as of the end of business on Tuesday, the docket sheet for this case is 184 pages long. It's 184 pages long. I mean, luckily computers permit us to, go back to the beginning. On page 184, it says complaint against Andrew Angland, Augustus Sol Invictus, Christopher Cratwell, Nathan D'Amigo, East Coast Knights of the Ku Klux Klan, James Alex Fields, Fraternal Order of the Alt Knights, Matthew Heinbach, Michael Hill, Identity Europa, Jason Kessler, Elliot Klein. I guess they're listed in alphabetical order. League of the South, Loyal White Knights of the Ku Klux Klan, Moonbase Holdings LLC, National Socialist Movement, National Front, Matthew Parrott, Michael Enoch Painovich. I don't know his name. Matthew Enoch, obviously after Enoch Powell. Painovich, I'm not sure. Robert Osmador Ray, Jeff Shirp, Richard Spencer, Traditional Worker Party, Michael Tubbs, and Vanguard America, as well as, and those are just the list of the plaintiffs. Anyhow, that's a heck of a lot of defendants, and I know that I know some of them. I don't know all of them, but I know some of the defendants, and that is a very long list of defendants who had very little to do with each other, which is kind of interesting to start with. They filed this on October the 11th, 2017, and it's now October the 25th of 2021. And so 4 years later, this case is just now selecting a jury. It's sort of astounding to me that it is selecting a jury, but it is, and it will go to trial, presumably sometime in November. The stages of litigation here are very slow because of so many defendants. They only issued an electronic summons to Richard Spencer on the November 30th of 2017. So service took a couple of months. Jason Kessler filed his motion to dismiss under 12b-6 on December 7th of 2017. Obviously, most of the motions to dismiss were denied, or we wouldn't be having a trial. Anyhow, it goes on. I mean, by the time the case was, what would have been 6 months old in April of 2018, right? Yeah, October. I should know that. My birthday is in April, and a half birthday is in October. So by the time this case was 6 months old, it was up to 300 filings. Well, yes, 300. The 300th filing was a notice of telephonic hearing on April 19th, 2018. Now, we go on, and this is, I guess, was this the first hearing? I can't tell if it was or not, but I wasn't looking carefully enough. But anyhow, it looks like our first transcript shows up as document 321 on May 31st of 2018. And we're still 3 years away from trial, more than 3 years away from trial. It goes on and on and on. I'm looking at a transcript for a hearing on February 20th of 2019, when the case was 1.5 years old. Oh, and I see something about order terminating David Duke. he wasn't even, David Duke was not even listed as a party in the original complaint. They must have amended it to add him or something, or merged him in somehow. But the scope of this, there entry 400 was another transcript before the magistrate Joel C. Hope. It's impossible, I guess, to convey what an epic case this is, what an epic litigation this is, unless I compare it to other large cases I've known. It's much bigger than the probate litigation for what was her name? Smith, the lady who married old Marshall, Anna Smith Marshall. I can't even remember her name at this hour of the night, but it was a very famous case. She was a Playboy model and a stripper who got an old friend of my grandparents, Mr. Marshall, and in Texas. And when he died, there was a big probate litigation about that. And anyhow, this is much bigger than that case, as I guess is reasonable, given how many defendants there were. But in addition to that, the number of lawyers, let's go back to the first case. When I set this docket sheet up to go from most recent to oldest, and the most recent to oldest, before you get to the case at all, you have to review the lawyers, and the list of lawyers and parties alone in this case occupies, out of 184 pages, it occupies, is it going to be 10? No, it's more than 10, it's more than 20. The list of lawyers and parties takes the first, this is astounding. We're up to 37 pages and we're still looking at list of parties and lawyers. We are now on page 43. This is just absurd. Let's see. It's passed by David Duke here. Good old David Duke. Richard Spencer, Catwell. I missed David Duke. I thought I saw him somewhere in here, but the list is just too overwhelming, I guess. David Duke settled out February 2019. Yes, that's his address. He was represented by himself. I guess he was smart. He got out of it quick. Anyhow, David Duke, Matthew Parrott, Traditionalist Workers' Party, Michael Hill, League of the South. Finally, I got out of the list of parties and Loyal White Knights of the KKK, East Coast Knights of the KKK, also known as East Coast Knights of the True Invisible Empire. And then on page 58, at the bottom of page 58, we finally get to what happened on Tuesday, October 26, 2021. And it looks like there was a transcript, copy delivered, Ray transcript request of something that happened 100 docket entries before. There was also a transcript of proceeding of trial day 2, held on 10/26/21. The parties have 7 calendar days to file with the court a notice of intent to request redaction of this transcript. If no such notice is filed, the transcript will be made remotely and electronically available to the public without redaction after 90 calendar days. That permits it. The trial might even be over by then, huh? Probably not the entry of judgment, but the trial will probably be over by the time the transcript is publicly available. Transcript may be viewed at the court public terminal or purchased before that date. Anyhow, and that's just the transcript of the second day. On the second day, how many? There are only what? There are only looks like 1, 2, 3, 4, 5 entries. Proposed jury instructions by Michael Hill, League of the South, and anyhow, then we get to Monday. On Monday, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. No, we're to Sunday now. On Monday from 13/11 through 3rd, so there were 10, only 10 entries on the first day of trial, and only 6 entries on the second day of trial. Let me just try to explain. In ordinary civil litigation, they call a case cancerous if there are 2 or 3, or this is what they used to say in Austin. The clerks used to say that a case was cancerous if there were more than 3 filings per week. The case had gone cancerous. Here, we're up to 1,326 docket entries in a case that's 4 years and 2 weeks old. It's comparable to the United States v. Microsoft case, where the United States was trying to break up Microsoft. It's comparable to the United States versus AT&T case. Over the weekend, what did we have? Over the weekend on Sunday, there were only three filings on a Sunday, the 24th. So they actually did kind of take a day of rest there. Only filed 2 letters and a trial brief for the plaintiffs, I guess. Trial brief, Rave Wadir, and prospective juror recusals for cause. And then on the 23rd, which was Saturday, how many we have? Only 3 on Saturday, 3 on Saturday, 3 on Sunday. And then we get to Friday. And Friday, let's see, we start at 1304. Friday was the 22nd. Okay, so there were only, oh wow. Very 1304 through it looks like there were only 304, they're 10. This is just amazing. It looks like there are going to be about 20 filings on Friday, the Friday before trial. No, more than 20, 21, 22, 23. Oh no, we're 22. There are 22 filings on Friday before trial. That's like a year of litigation in some cases. Well, a couple of months anyhow. 21st, I mean, they were getting ready for trial, but they're fighting hard. anyhow, what you've got to understand is every one of these docket entries is at least, at the very minimum, 1 hour of attorney time on each side. And since there are 57 pages of lawyers, 57 pages worth of lawyers and parties, pro se parties, we are talking an epic, probably on the order of 200 attorney hours every day. 300, it wouldn't be unrealistic to say as many as 300 attorney hours every day on this case. In, well, certainly the pre-trial, the trial preposition period, because 8 hours a day per lawyer, how much would it take to get to 300 per day? There are at least 20 or 30 lawyers involved in the case on both plaintiffs and defendants side. They all put in at least 8 hours, maybe 10 to 12. And there you've got 300 hours. Now let's imagine that that's billing at $200 an hour minimum. Some of them are going to be much more than that. That then gives you a total of, I'm going to have to, my brain is fuzzy at this hour of the night. So I've just got to look and to see 200 times 300, $60,000 a day. I thought that was going to be it, but I couldn't believe it. Yeah, $60,000 a day accruing in attorney's fees. That's a realistic estimate for this case, $60,000 a day. And what is the purpose of this case? You know, according to my understanding of the plaintiff's real purpose in this case is to destroy the defendants, not necessarily to win incredible judgments against them, but simply to wear them out and destroy them by forcing them to fight. I cannot quite wrap my head around the complaint. I have looked at it, and there are just so many ifs here, because what there was a riot. Who caused the riot? Who was really injured in the riot? You know, we've all heard of Heather Heyer, and we've all heard of James Alex Fields. I notice that this man who's serving several life terms, on October the 19th, which is a week ago today, on October the 19th, they entered there was a motion to modify Magistrate Judge Hope's order on sanctions against James Alex Field. Who filed it? Memorandum opinion and order. For the fun of it, let's take a look at this motion and see if we can bring it up. Or am I still connected to Pacer? I'm not sure. May have to sign on again. This for Jessica. It's a 16-page document. Every lawyer in the case is going to have to read it. That's at least an hour of billable time. Plaintiff's motion for modification of Magistrate Hope's October 15th, 2021 order on sanctions against defendant James Alex Fields, who is in prison and will never see the light of day ever again, barring a revolution in this country. Pursuant to Rule 72, plaintiffs respectfully move this court for a modification of Magistrate Judges Hope's order granting in part and denying in part plaintiff's motion for sanctions against defendant James Field. In that order, James Hopp made two critical and correct determinations. First, Judge Hopp held that Field's blatant refusal to appear for a properly noticed deposition warranted a sanction prohibiting Fields from testifying in his own defense at trial. This man's in jail. I wonder what happened if he didn't appear at trial. Do you suppose the prison guards wouldn't give him leave or kept him in his cell? And second, Judge Hopp held that adverse inference jury instructions, if tailored to the particular request for admissions to which Fields invoked the Fifth Amendment, would be a proper remedy for the unfair prejudice plaintiffs suffered as a result of Fields' assertions of privilege. Okay, so you don't really get a Fifth Amendment defense, Fifth Amendment refusal in civil court. So I guess that's fair, more or less, except that the man's in jail. There's no sanction worse than, multiple life term sentence in prison, is there? I mean, up to a point, death would be a mercy for a person who drove his car when someone had a heart attack. But the court left unresolved two narrow related issues that are appropriate for this court's de novo consideration in the first instance. Judge Hopp left it to this court to determine whether, in addition to being prohibited from testifying in his own defense, Fields should also be prohibited from testifying as a witness for other parties, including his co-defendants. What? Judge Hopp also left the door open for plaintiffs to propose revised adverse inference instructions appropriately tailored to the request for admissions, RFA, to which Field invoked the Fifth Amendment. Resolving both issues is crucial to give effect to Judge Hopp's sanctions ruling to level the evidentiary playing field and to facilitate the parties' preparation for efficient presentation of evidence at trial. Accordingly, the court should modify the order in the following respects at this time. For the same reason that Judge Hopp already ruled that Fields should not be allowed to testify in his own defense at trial after blatantly refusing to testify at a deposition, this court should rule that that Fields cannot testify as a witness for his co-defendants. In addition, to assure that plaintiffs are not unduly disadvantaged by Fields' invocation of the Fifth Amendment in response to specific RFAs, this court should approve plaintiffs' proposed adverse inference instructions, which are narrowly tailored in accordance with Judge Hopp's guidance. Let's think about that. I can't imagine I have never seen, I have to say, anyone invoke a Fifth Amendment privilege in relation to requests for admissions, RFAs. So, yeah, I guess that was kind of a dumb thing to do. Sorry, James Alex Fields. I feel very sorry for James Alex Fields, actually. My heart bleeds for anybody sentenced to multiple life terms in prison and to be vilified for what cannot properly, in my view, be called a murder. But anyhow, they want to deprive other defendants of the benefit of his testimony. And that seems monstrously unfair to me. But I think it's a good indication of how this case is going to go. Plaintiff's motion for sanctions against Fields, including a detailed statement of facts and procedural history of the case. Judge Hopp's decision, too, set out the necessary factual and procedural background for the resolution of these issues. We therefore dispense with a comprehensive discussion of Fields' flagrant, wanton discovery misconduct and focus only on the background related to the discrete questions before the court. After being served by the plaintiffs with a proper notice under Rule 30B, Fields stated that he would refuse to appear via video conference or testify on videotape at the deposition scheduled for February 25, 2021. Judge Hopp easily found that sanctions were authorized and appropriate under Rule 37D1A1, which allows the court to order sanctions if a party fails after being served properly with notice to appear for that person's deposition. I guess so. If he really refused, yeah, I can't say that that's unreasonable. Plaintiffs had argued that precluding Fields from testifying at trial was an appropriate sanction because Fields had deprived the plaintiffs of opportunity to cross-examine him and elicit evidence during discovery. I guess they got a point. I can't argue with that. I'm not going to argue with that. I feel sorry for the man, but that was a boneheaded thing to do. Judge Hopp agreed in significant part, holding that prohibiting Fields from testifying in his own defense at trial is an appropriately tailored sanction for Fields' failure to appear for his properly noticed deposition. Order at 33. He could have appealed and taken the fifth then. I mean, he might have been at most sanctioned by an adverse inference at that point. Anyhow, Judge Hopp explicitly reserved for this court to decide whether Fields should also be prohibited from testifying if called as a witness by one of his co-defendants. Whether any other party may call Fields as a witness is a decision is reserved to the presiding district judge. Fields' invocation of Fifth Amendment. Fields was convicted in a Virginia state court of murder and 8 counts of malicious wounding as a result of his attack at Unite the Right. His appeal of that conviction is pending. In response to dozens of RFAs and interrogatories by plaintiffs about key issues in this case, including Fields' motivation and state of mind while driving his car into a crowd of people and his history of espousing violence against members of racial, ethnic, and religious minorities, Fields asserted that the Fifth Amendment privilege of incrimination against self-incrimination. As Judge Hopp recognized, even if the Fifth Amendment privilege were validly invoked, Fields' refusal to admit or deny relevant facts stands in stark opposition to the otherwise liberal discovery rules and undermines to some degree the trial system's capacity to ascertain the truth. Order at 34. Therefore, Judge Hopp said an adverse inference based on a refusal to answer specific questions in a civil case is an appropriate remedy as it provides some relief for the civil litigant whose case is unfairly prejudiced by his adversary's assertion of the Fifth Amendment. Plaintiffs sought both an adverse inference instruction and an order that each RFA Fields refused to answer on the basis of the Fifth Amendment be deemed admitted. That's normal. That's normal. That's totally normal. But Judge Hopp denied both requests without prejudice, noting that the problem with the plaintiff's adverse inference request was that their proposed instruction was not appropriately tailored to each RFA. Okay, finding that plaintiff's catch-all adverse inference jury instruction inappropriate. This is one motion on one defendant who has no capacity to defend himself because he's already been convicted. This is how much energy they are putting into this case. They are basically trying to hang a man twice. Look at this list of lawyers. Even single-spaced, it goes on for 3 pages. Counsel for plaintiffs, certificate of service. Yeah, goes on for another 2, well, just 2 pages for the defendants on this one motion. Can you imagine trying to keep up with this, even if you have a staff of lawyers working on it? I mean, each lawyer has a legal secretary and some paralegals working for him. And wow, we are just in a position of bleeding the whole world to death with legal fees. I'm going to save this since I've already paid for it on Pacer. And it's interesting. It's a tiny little, this is a tiny little event the week before trial. A tiny little event. Infinitesimal. And the order that they're appealing or moving for modification of is, it's 12 days old now. And they're basically saying, yeah, this guy is screwed, but we want to screw him just a little bit more because nothing other than total obliteration of some defendants is ever going to be satisfying. I mean, I can't type against defendant James Alex Jr. I'm just, I mean, I know a little bit about the law, I guess. Document 1266 filed 10/19/2021 in case signs B. Kessler. No, Jason Kessler. I feel for him. I feel for all the defendants here, because this is one of those cases that the lawyers got hold of and that the lawyers are basically milking for everything it's worth, and quite a bit that it's not worth. That's the really amazing thing, is that there's really no way that this case has that much value as any kind of case at all. It was a riot, and they're accusing some of the rioters of taking away the civil rights of some of the other rioters. That's what this case is about. Rioters taking away the civil rights of other rioters. And wouldn't it be both ways? I don't quite understand why there's no counterclaim in this case. But anyhow, I suppose I should close again by getting the quote from the Inferno quite right. And so I'm just going to close with that. Yes, yes, yes. It's an amazing, amazing thing we live in, this world. Wasn't it Canto 4? Maybe it was not. Words of Hell. What was I quoting from? Canto 3 Italian. Per me si va nella città dolente, per me si va nell'eterno dolore. Per me si va nell'eterno dolore, per me si va tra la gente perduta, la perduta gente, sorry. Giustizia mosse il mio alto fattore, fecemi la divina potestate, la somma sapienza il primo amore. Dinanzi a me non fuor che cose creati, se non eterne, e io eterna adoro. Lasciate ogni speranza, voi che entrate. That is the part that's relevant to law. Lasciate ogni speranza, voi che entrate. Abandon all hope, ye who enter here. Queste parole di colore oscuro, video e scritti al somo di una porta, perché maestro il senso l'orme duro. I saw these words written above the door, and I asked, Master, their meaning is hard for me to understand. Il senso l'orme duro. Per me si va nella città dolente, through me the way to the woeful city. Per me si va nell'eterno dolore. Per me, through me the way to eternal sorrow. Through me the way of the lost people. Per me si va tra la gente perduta. Through me the way of the lost people. Justitia mosse il mio alto fattore. That's where I started here. And that's what's really bad and hopeless. There is no justice, but the people are lost. And this case is about eternal sorrow. And Charlottesville is una città dolente. That's a woe, the city of woe, city of pain. But justitia mosse il mio alto fattore. I see no justice in year after year after year, 4 years and two weeks grinding against the words, the billions of words. There are probably billions of words that have been filed in these 1,326 filings in court. Some of those are transcripts that goes on for pages. Some of those are 100-page motions. Justitia mosse il mio alto fattore. Justice moved my maker on high. It did not in the inferno of Charlottesville courts. Fecemi la divina potestate. It was not made by divine power. It was made by clumsy human mugwumps. La somma sapienza, il primo amore, supreme wisdom and primal love. There is none of that here. There is none of that in the plaintiff's case. There is none of that in the defendant's case. Although I will say this, I think that there was some primal love on the part of the defendants trying to preserve that beautiful statue, that monumental statue to Robert E. Lee, to prevent it from becoming a horrible source of pain and derision, of dolente. It has become the symbol of that città dolente and that path to eternal sorrow. And all the people of Charlottesville are lost people. Dinanzi a me non fuorche cose creati, se non eterne, e io eterna adoro. Lasciate ogni speranza voi che entrate. Before me was nothing created except eternal things, and I last forever. Abandon all hope, ye who enter here. That should be written over every goddamn federal courthouse in the United States. Lasciate ogni speranza voi che entrate. In memory of my mother, who taught me to read Italian, think about heaven and hell. I am going to close now. Good night, everybody, from the city of New Orleans, Louisiana. I hope you're all well, and I hope that the 27th of October of this year is a day that we remember that it is only in dying that we are born to